The VA appeals process is undergoing a complete overhaul. Understanding these changes will be important for you to know how best to navigate your claim through the system. In our first video, we gave an overview of the whole system. In this video, we're going to focus on the new appeal process that takes place at the regional office, known as the RO, where you file your claim. This is the new layout of the VA appeals system. Once an initial decision is reached, the veteran has three options for keeping the claim going. The first option is to file a supplemental claim with the new and relevant evidence. The second option is to ask for higher-level review. Lastly, you can file an NOD to go direct to the Board of Veterans' Appeals, also known as the BVA. Let's start from the beginning, filing a claim. When you file a claim, the VA has a duty to assist you to win your claim. This duty could mean the VA must go to get service records, medical records, and Social Security records. Sometimes, the duty to assist includes getting the veteran a C&P exam. The VA's goal is to issue a rating decision within 125 days. Although similar to the way the rating decisions used to be laid out, now it must include the following: identification of the issues decided, summary of evidence considered by the VA, summary of applicable laws, identification of findings favorable to the claimant. The VA is then bound by these favorable findings throughout the adjudication appeal, absent clear and convincing evidence to the contrary. If denied, identification of elements leading to denial, explanation of how to obtain or access evidence used in making the decision, and identification of criteria that must be satisfied to grant service connection or the next higher level of compensation. Once an initial decision is issued, a veteran can hire an attorney or agent. It used to be that a veteran had to file an NOD first, but now a veteran can hire an advocate, and the advocate can help decide what way to move the case forward. If you disagree with the decision, then you have three choices to move forward. Those options, again, are file supplemental claim, higher level review at the RO or NOD to the BVA. The veteran has 1 year to enter his claim into one of these lanes if he wants to continue his case. Let's look at the supplemental claim. To file a supplemental claim, the veteran must submit new and relevant evidence. New and relevant evidence replaces the current new and material evidence standard. Relevant is defined as evidence that tends to prove or disprove a matter in issue. Importantly, this new standard is lower than the old new and material evidence standard. Remember, the supplemental claim must be filed within 1 year of the decision. The main benefit of this lane is that it allows the veteran to file new evidence, whereas higher review does not. If the claim is again denied, then the veteran still has all three options going forward: another supplemental claim, the higher level review, or an appeal to the Board of Veterans' Appeals. The next option is higher level review. Within 1 year of the decision, a claimant can request higher level review. You can request it to be at the same RO or a different RO. No new evidence may be submitted. Review is de novo, which means the new decision-maker is not bound by what the old one decided. Notice of the higher level review decision must include a statement indicating whether evidence was submitted and not reviewed, and the options for having that evidence reviewed. An important takeaway with this lane is that the decision-maker will not consider evidence that was not before the adjudicator that made the first decision. If you submit new evidence, then you will most likely have to have it considered through a supplemental claim if you want it considered again in the RO. If you disagree here, then you can file another supplemental claim or make an appeal to the BVA, which is the third and final choice in the new VA appeals process. The board is the last stop for an appeal in the VA system. To go to the BVA, you file a notice of disagreement, aka the NOD, within 1 year of the decision. It used to be that the veteran had to file an NOD, get another decision from the RO called the statement of the case, and then file a subsequent appeal. Now, the NOD takes you straight to the BVA. The NOD must be filed directly with the BVA. There are certain requirements for the NOD. It must be in writing and identify the specific issues with which the veteran disagrees. It must be on the VA's specified form. The veteran can request a hearing before the BVA and/or submit additional evidence with the NOD, or they can request a review without a hearing or additional evidence. The VA is required to develop a policy to allow for modification of the NOD after it has been filed. Lastly, it is important to understand how this new program protects the effective date of a potential award. The effective date is the date from which the VA will pay benefits. Usually, it is the date of the last reopened claim. With the new system, as long as you choose one of the 3 lanes within a year, then your effective date of any claim granted should be the date of the claim you filed at the beginning.